Hello, and thank you for joining us. This is No Soundbites Allowed, and I am your host, Michael Voss, Dragon the Southern Tier. I'm happy to be here with you today as we talk about a very important issue, a court case that has just been decided and will have a massive impact on your life. Now, this isn't the news that you're being told about at this time. In fact, the news media is busy trying to distract you from this important case. You may recall that right now you're hearing about the Omicron variant, which is milder and is affecting those who are vaccinated, as we're hearing from South Africa, and as we have seen in the first case in the United States in California. And the news media is very happy to tell you that you have to be prepared for this, that potentially we need more lockdowns for this milder form of the pandemic. But that's not the news story we want to mention. We're talking about court cases, and I don't mean the court case like the Ghislaine Maxwell case, which is important. It's about sex slavery in the United States that has been enabled, and the various politicians and members of Hollywood that were involved and allowed this to go on for well over a decade. While that case is important, it is also something that is restricted from the public. There is no media access to this, unlike the Kyle Rittenhouse case, because a federal court judge has denied the ability for there to be any news media covering this directly. And we want to make sure it's not about the case of Alec Baldwin, another story that's very big in the news media that the social media want you to focus on. In this case, where we are now hearing from Alec Baldwin himself, as he is telling ABC News he didn't pull the trigger, that somehow this firearm miraculously fired by itself while in his hands as he pointed it at the camera woman and the director, and it just miraculously went off, even though witnesses have already been stating he did in fact do this. But that's not the story we're talking about. We're not even talking about the other really big entertainment news, the trial of Jussie Smollett, an actor who, in his hate of American principles, in his hate of then President Donald Trump, in his then hate of conservatism, he decided to fake an attack to increase the racial tensions in the United States 3 years ago. And now his lawyers are claiming that he is a victim, not the perpetrator of a hoax, but the victim of his own hoax. Even as we get to hear from witnesses who have clearly stated that the actor staged the attack and wanted to be fake beaten as to improve his standing both in media as well as to promote his far left ideology. All of these cases are important, but perhaps not even as important as what is now going on and has flooded the social media. The internet overlords have made it very important for people to be following the abortion issue, a hot button issue in the United States for many decades, with the nation being almost essentially evenly divided on this ability to kill babies in the womb after 15 weeks of being in the womb. And we now see that even Justice Sotomayor, a Supreme Court justice, has now introduced politics into the discussion, something that is verboten for a Supreme Court justice. The Supreme Court is supposed to be apolitical. That's why they are the third branch of the United States government. And yet we see that the far left is inflaming the emotions of half the nation by making this a political discussion and not a legal one. These are all very important issues, and they all need to be discussed. And yes, some of them are far more important than others, but that's what you are being told about. And that's a big deal, because we were speaking with one of our associates, a friend of ours, who's in the political arena, and they didn't even realize that there was an announcement yesterday, December 1st, that came out from the Ninth Circuit Court in California that is going to affect millions of lives, and news media doesn't want you to notice it. They want you to forget about it. But we want to discuss it with you because it will impact your life. Now, before we go forward, we do want to mention, if this is the first time that you are seeing our channel, we want to welcome you and we thank you for joining us. In addition, we want you to know that we do long-form political commentary. And every Sunday at 2:30 p.m. Eastern Standard Time, we do a live stream with you. We reach out on YouTube, Facebook, Twitter, DLive, essentially all the social media that we can access to be able to hear your voices in your tweets, in your chats, and even your phone calls from anywhere in the world. And we do that because we believe in the First Amendment right of everyone in the world. It is an unalienable right of birth that you should be able to speak, even if your government disagrees, even if the internet overlords disagree. You should speak and be heard. And every Sunday at 2:30 p.m. Eastern Standard Time, we do hear you. And we look forward to seeing you every Sunday to join us to tell us what you think about the issues that are affecting us all across the world. Now let's address what this very important case out of California, out of the Ninth Circuit Court, which is the next court just below the Supreme Court of the United States. It's a big deal. It affects millions of people. It sets precedents across the nation, and they have been doing this against the best interest of the American people. In fact, they have been reinventing laws and the Constitution. You may recall that on this channel in March, we actually covered a decision from the Ninth Circuit Court that essentially eviscerated the Second Amendment, that they took away your right to defend yourself outside of your home. This is something that will affect women. This will affect kids in schools. This will affect people who are being attacked by mass shooters, even in churches. This is going to have a major impact. And on March 2021, four judges dissented against this obscene way of looking at the Second Amendment, saying that you do not have a right to be able to defend yourself as soon as you leave your home. And the dissent was very, very clear in what they wanted to make sure the American people heard. And on page 128 of the decision, it was O'Scanlan, the circuit judge, who dissented along with Callahan, Ikuta, and R. Nelson, circuit judges. And in that decision, O'Scanlan, I know I got his name wrong, I apologize. He says, the Second Amendment to the United States Constitution guarantees the right of the people to keep and bear arms. Today, a majority of our court has decided that the Second Amendment does not mean what it says. Instead, the majority holds that while Second Amendment may guarantee the right to keep a firearm for self-defense within one's home, it provides no right whatsoever to bear, in other words, carry that same firearm for self-defense in any other place. This holding is as unprecedented as it is extreme. While our sister circuits have grappled with and disagreed over the question of whether public firearms carry falls within the, quote, inner core, end quote, of the Second Amendment, we now become the first and only court of appeals to hold that public carry falls entirely outside the scope of the amendment's protections. In so holding, the majority reduces the right to, quote, bear arms, end quote, to a mere ink blot. The majority's decision undermines not only the Constitution's text, but also a half a millennium, 500 years of Anglo-American legal history, the Supreme Court's decision in District of Columbia versus Heller, and McDonald versus City of Chicago, and the foundational principles of American popular sovereignty itself. I respectfully dissent. We want to make sure that you understand exactly what we're talking about here. For those who are not familiar from other countries that may be watching this program, our allies and friends over in the United Kingdom, in France, Germany, Australia, Canada, New Zealand, we want to make sure you understand because you don't have freedom like the United States. Your Constitution doesn't guarantee your right to free speech, nor does it guarantee your right to self-defense. But in the United States, by birth, these are guarantees. And in fact, in the Constitution, it states clearly, Second Amendment, a well-regulated militia being necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed. The key words there, shall not be infringed. Nowhere in that statement is there a limitation on being able to have a firearm in the public in your daily life. There is no stipulation that you are restricted to only being able to defend yourself in your home. There is nothing in the statement that says for hunting. There is nothing that says for recreation. These are not stated, nor are they implied, especially if we go back and look at the time that this was written, right after the United States declared its freedom from the United Kingdom. There was no insinuation that the American people would be limited in the type of firearms they could have, nor in where they could bear those arms. And in fact, for those who'd like to say that you could only use a musket and a single barrel, single shot, they forget that in the time the Constitution was written, machine guns did, or rather multi-barrel, multi-shot firearms did exist. I know Joe Biden doesn't understand that, doesn't remember that up until 1934, there were no restrictions on any firearm that an American citizen could own. But let's go further. So we know that the Ninth Circuit Court has revised, not just revised, they have created their own constitution. They have created their own amendments. And in that, they have defined the American citizen's ability to defend themselves to be restricted to your home. So women who own firearms, and there are tens of millions that do so, to be able to protect themselves from rape and sexual assault are not able to do so, according to the Ninth Circuit Court. That individuals, teachers, and other individuals at schools there to protect our children are not able to do so because, according to the Ninth Circuit Court, they don't have that right. That individuals who are going to churches or another public venues do not have a right to defend themselves from mass shooters, according to the Ninth Circuit Court, and their new rendition of the Second Amendment, ignoring shall not be infringed. But it doesn't end there. I wish that were the worst of all of it. But in fact, it has gotten even worse. Because just yesterday, December 1st, we see that the Ninth Circuit Court came out and they have decided a case that will have a huge impact across this country. And this case will now be going to the Supreme Court. What happened is that California has now taken the position, like New York State, that you are limited in the number of bullets that you are able to have, that you are limited to a magazine a size of 10 rounds or less, that you are limited in your capacity to be able to defend yourself to just 10 rounds. Now, this is important and this is critical. And you may say to yourself, but why? Why would that be important? Well, understand, criminals who violate the law on a regular basis, that's why they are considered criminals, don't care. They will use as many rounds as they possibly can. But you do not have the right to defend yourself to the fullest ability possible. The Ninth Circuit Court does not recognize that. In fact, the Ninth Circuit Court has now created a new statute of law that if you have up to 10 rounds, you are a law-abiding citizen, and on the 11th round, even in self-defense, you are now a criminal. I want that to sink in. They have now made the decision that you could have 9 rounds. in trying to defend yourself from, say, someone trying to rape a woman or trying to, shoot a school. And you are limited at the 9th round, the 10th round, you are legal. And this is okay, except as long as it's in your home. But if you're outside your home, you have already broken the law according to the Ninth Circuit Court. And at the time, the moment you hit the 11th bullet, you have compounded your crime. Does this make any sense whatsoever? Does that sound logical at all? And should we even expect logic coming from the far left? Because it's the very same far left that encompass California and encompass the Ninth Circuit Court that also tell us things like in California that gun control was instituted in the United States, which was created first in 1934 because of the Chicago Valentine Day murders. But instead, they are giving us a rendition of a redacted, a changed, altered, revisioned history where gun control laws were created in 1967 because of the Black Panthers. Now, under this view from the far left, understand, the Black Panthers were able to have firearms and bring them into the courtrooms in California. And they believe that gun laws were changed to negatively impact blacks in America. But yet, that very same left-leaning viewpoint does not believe that blacks should have firearms, nor do they support blacks having firearms in excess of 20 rounds. Instead, they want to totally disarm the American blacks. Even though they blame this on the right, they say this is racist, that these gun control laws were created as a form of racism, and yet they are willing to support that racism, as they allege, to deny black people the ability to defend themselves outside of their home with anything more than 10 bullets. Isn't that more racism on top of the racism they are alleging, which isn't historically accurate? Well, it gets a little more confusing than that. Because what exactly did the Ninth Circuit Court say in California on December 1st? Something that you're not being told across the major news media. Why are they avoiding this subject just as they did in March? Well, according to the Associated Press, we see that the 7-judge majority of the Ninth Circuit Court stated, and I quote, "The California statute outlaws no weapon, but only limits the size of the magazine that may be used with firearms, and therefore it is not in violation of the Second Amendment." Further, they write, quote, "The record demonstrates that the limitation interferes only minimally with the core right of self-defense, as there is no evidence that anyone has ever been unable to defend his or her home and family due to the lack of large capacity magazine, and that limitation saves lives." Well, the first question I would ask about this is, has anyone actually checked that? Is there any data that has been done to check whether or not people were using large capacity magazines and how many times they fired? Because to my knowledge, there isn't. But that being left aside for a moment, and I want to come back to this question they're saying about there is no limit on the type of weapon, the gun bans. That's coming up soon. But let's look at this statement they're making about the limitation, that the limitation they are supporting, the limitation interferes only minimally with the core right of self-defense. In fact, let's go from the San Franciscoist and look at a more recognized major news media outlet, the LA Times. The LA Times quotes, and they state that the California large capacity magazine ban, approved by voters in 2016, limits possession to magazines that hold 10 or fewer rounds of ammunition. A district judge and a divided three-judge Ninth Circuit panel struck down the law, which Tuesday was revived. Quote, large-capacity magazines allow a shooter to fire more bullets from a single firearm uninterrupted, Justice Graber wrote, and a murderer's pause to reload or switch weapons allows potential victims and law enforcement officers to flee or to confront the attacker. This is a bald-faced lie. This is not true. This is a misconception at the worst levels, and we will prove it. Going on, the court noted that Washington, D.C. and 8 other states have also imposed restrictions on large-capacity magazines and that 6 other federal courts of appeals have upheld the laws. They're speaking notably about New York State and the New York State SAFE Act, which went into place in 2013 under the unilateral rule of the Democratic Party and now disgraced former Governor Andrew Cuomo, which is still in court and being decided, although a lower court has already struck down the 7-bullet limitation as unconstitutional. Quote, the ban on large-capacity magazines has the sole practical effect of requiring shooters to pause for a few seconds after firing 10 bullets. This is a lie. To reload or replace the spent magazine. Nothing in the record suggests that the restrictions imposes any more than a minimal burden on the Second Amendment right to keep and bear arms. Again, any more than a minimal burden on the Second Amendment. The Second Amendment states, again, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. This is the whole reason why there was the Heller case that went to the Supreme Court. Shall not be infringed. When we are listening to the various versions from the far left, saying that there is only minimal interference, and hearing the Ninth Circuit Court and Justice Graber say that it is a minimal burden, they are saying it is an infringement on the Second Amendment. The Second Amendment is clear. There is no way to reinvent or somehow reimagine shall not be infringed. Minimal infringement is infringement. Any limitation is infringement. The Second Amendment directly states it cannot be done. And it is not in regard, and this does not matter whether or not you want to go hunting or you want to go recreationally shoot, because the Second Amendment doesn't care about that. It has nothing to do with that. You have a right to have a firearm, period. And up until 1934, you had the right to own any firearm that you wanted. That was the facts. Now, we have limited that since 1934, but again, there is no burden. Any burden placed on the Second Amendment is illegal. It is unconstitutional by definition. And yet the Ninth Circuit Court has decided they have a new way of looking at this, that they have a new version. And their justification for doing this is perhaps one of the most stupid lies we have heard. It is a lie, a misconception that has been said over and over and over again. In fact, we covered it in 2013, right before we saw that Governor Andrew Cuomo, the disgraced governor, came out with his SAFE Act and decided that he wanted to limit firearm rounds. We had individuals like the former mayor of Binghamton, New York, in the southern tier of New York State, when we interviewed him as he was speaking to the Binghamton City Council in 2013, trying to advocate to remove the rights of the Second Amendment from American citizens in his city. And he stated, as you can hear, strong lobby, and there are many people in America very strong, to the extreme in some cases, right, on the Second Amendment. Some of those, in looking over the website for the Mayors Against Illegal Guns, there is the argument that would be said. If everything was passed, would that stop an event, say, like the Binghamton shootings, which I know you personally did everything you could about, and we spoke about it at that time.
Right.
Or the San Antonio shootings, or 80% of other firearm shootings.
Well, I do believe that, the big thing here is that, yes, some of these people have gotten their guns legally, but one of the provisions is, do they need such big magazine clips? Intervening in there's been some very heroic people who without guns have prevented more carnage by, going after a perpetrator. If a perpetrator has to reload and doesn't have more than 7 bullets in a magazine, there's opportunity to, make your heroic activities mean something.
And that is just not true. That's not true. In fact, there are millions of individuals who use a firearm that are legal firearm owners across the United States, open carry, concealed carry, and in their homes and outside of their homes, that have stopped more incidents with firearms than heroic actions. That's just a fact. It has always been a fact. It was a fact in 2013. It's a fact in 2021. But this is the argument that you hear. And you have to understand, this is the far left progressive view. Former Mayor Matt Ryan, who I know and have known for the better part of about a decade, is wrong. And he doesn't know what he's speaking about. He's talking about magazine clips. I remember covering magazine clips. And on July of 2018, there was this coverage that we provided about magazine clips.
Quickest way to know if you're debating somebody who knows anything about guns is more of a personal pet peeve, but I found this to be true. People with little to no knowledge on the subject are the very first ones to call for further regulations and restrictions on your rights. This is how I know who I'm debating and whether or not I've won the debate. Clips and magazines. Anybody know the difference? Okay. Anybody ever heard of the guy had a high capacity clip? No. I just heard of it. This is a magazine. Your bullets go in this. This goes up inside your gun. That's what this is. It's a magazine. That's a clip, and that's a clip. That's right. When somebody talks to you about all your high capacity clips, you're not talking to somebody who knows what they're talking about. They don't. A clip only holds bullets for transport and loading purposes. You put the clip over your gun, you press down on the bullets, it comes out of the clip, you take the clip, you throw it away. The magazine is the part that holds the bullets in it. So, just a personal pet peeve, but whenever you say, we got to outlaw high capacity clips, go ahead. I don't care, go. Okay. Because once they use up, they're no good no more. Go, take them. I don't care. Take them and have at it. No, I actually don't. I don't want you banning anything. I don't want you banning a damn thing.
I think the point has been made, and I think it's very clear. Mayor Matt Ryan, former Mayor Matt Ryan, 2013, no idea what he is talking about. Because as you heard him say, he wants to ban high-capacity magazine clips, which is the only purpose of a clip is to load a magazine. It is a simple strip of metal. He has no idea what he's talking about. Yet he wants to impose his will, his lack of knowledge, to restrict the Second Amendment rights of individuals in the city of Binghamton. And we see that the Ninth Circuit Court is using that same kind of logic, the lack of knowledge of firearms, to try and decide to reinvent the Second Amendment. Because they are infringing on the Second Amendment by definition. But this is their progressive ideology speaking, not any knowledge, not any facts, not any legal standing. They just want it to be that way. And that's got to be very upsetting. It should be very upsetting for everyone when they hear this. And when we hear them say that they are redefining this. Again, they want you to understand your 9th, your 10th bullet, that's legal. The 11th bullet, you've now committed a crime. Why? Why is that a crime if you're trying to defend yourself? Whether that's in your home or out on the street. Why is a woman on the 11th bullet now some kind of criminal? It's very upsetting. But it doesn't end there. You see, in New York State, we saw that New York State said, well, you can't have 7 rounds. As reported by the Buffalo News, the appeals court upholds the SAFE Act, but ruled against the 7-bullet limit. This was in 2015. In 2015, judges rightly looked at this and said a 7-round limit, which was one of the key components of the disgraced, former governor Andrew Cuomo, this was his big deal, that you could only have 7 rounds. And we said, this case validates a simple fundamental truth about gun control, that it is possible to have strong laws that keep our community safe, while at the same time respecting the rights of law-abiding gun owners. This is what was being said by Andrew Cuomo, the now disgraced sexual assault. He was guilty of 11 sexual assaults, as well as killing 16,000 people because of his executive orders and his overreach of government. That's interesting, because I want you to understand, and I want to go back over this. The Ninth Circuit Court says that the whole idea is that large capacity magazines allow for more bullets to be fired and that people will be safer without them because of these dangerous, horrible assault rifles, which is non-existent. You mean semi-automatic rifles. And that this is going to make you safer. Except that's a lie. In 2013, New York State said you can't have more than, well, initially they said 7 rounds, and then they amended it after they lost in court to 10 rounds. California, since 2016, has said you can't have more than 10 rounds. This is the law. And when we reviewed this back in October of 2017, and we did an in-depth look at firearms and mass shootings across this nation using all data that was available, and in particular looking at the FBI's data, we found that the difference in the firearm murders in California, as an example, from 2014 to 2016, they increased, even as they put in the new laws. And that the reality is rifles, the one thing you keep being told, the AR-15, the very thing that Beto, the fake Hispanic Robert O'Rourke, who's running for governor of Texas, wants to take away from you. The very thing that you have heard Joe Biden say that he wants to take away from you, that Kamala Harris has said that she wants to take away from you. These semi-automatic rifles are the least deadly thing that you could be facing. In fact, knives routinely are 4 to 6 times more deadly every year. More people die because of knives and because of just by knives alone than rifles in every state every year forever. And if you think in 2017, well, Mike, that data is old. This is California from 2011 to 2020. And they passed their law in 2013, similar to New York's law, which was in 2016 for California. From the FBI, homicide crimes by type of weapon used, 2016 to 2020, we see that rifles, 37 people died because of a rifle. It is 1.9% of all people who died of a homicide in California. This includes suicides. This includes every type of rifle, including the AR-15, the AK-47, the Ruger M14, Mini 14, and every other type of rifle you could possibly name. All of them put together 1.9% of all homicides in California in 2016, 2% or 36 of the people who died in 2017, 24 people or 1.4% in 2018, 34 people or 2.1% in 2019, 41 people in 2020 or 1.9%. Do you see a commonality there? It's not the firearm and it's not the gun. Excuse me, it's not the firearm and it's not the number of bullets. The numbers don't change. In each of these years, 2016, 280 people died from knife attacks in California, 258 in 2017, 252 in 2018, 252 in 2019, 292 in 2020. It's a very clear fact. Rifles, whether you want to call them assault weapons or you want to call them assault rifles, or if you just call them a semi-automatic rifle, are not the problem. The number of rounds are not a problem because the number of homicides in 2016, 1,900, 1,800, 1,700, 1,600, 2,200. California isn't saving lives with this. In fact, I want you to see something because you heard earlier when we saw Binghamton Mayor Matt Ryan, who said, well, there needs to be a pause that will allow someone to heroically save lives. We see that the circuit court was talking about the pause, the shooter's pause for a few seconds after firing 10 bullets to reload or replace the spent magazine, that this will save lives. You know, it's very hard to find this because this is a video from 2013. This is from the state police in Indiana. And this is a demonstration of exactly why the number of bullets and the type of magazine make absolutely no difference. No, they're not talking about clips because, as we have learned, that's just idiotic. No. The very thing that the Ninth Circuit Court is saying is a reason to infringe on the Second Amendment. And I want you to see something. This is an unskilled woman firing, and I want you to see exactly what happens as the Indiana State Police showed us.
30 rounds with 6 rounds from 5 separate magazines. Christie's time was 26.93 seconds to
26.93 seconds, 5 magazines with 6 rounds each. Less than 30 seconds for 30 shots. That's less than a second per shot. This is what the Ninth Circuit Court said. You saw her change the magazines after 6 shots, not 10. This is the reload, and I want you to understand, this is the reload that the Ninth Circuit Court just said is going to save your life. This is the reload that we hear from Mayor Matt Ryan and the far left. This is the miracle moment that you're going to save your life. And you just saw this. 30 seconds, less than a second per bullet, and that's with changing 5 times. It gets even worse.
To fire those 5 6-round magazines. Now, Christie's time is a bit longer than Jim's time, but what we're trying here is to demonstrate the impact of the effect of the magazine restrictions on the time. That is the time it takes to shoot 30 aimed shots. So, to review, Christie's times for 2 15-round magazines.
By the way, and you can see the full video and be able to see exactly everything that they just demonstrated. But for the record, Jim is an expert marksman. An expert marksman. Christy is a novice shooter. The differences are the difference between an expert and a novice. These are the times in seconds for 30 rounds from an expert, and these are now Christy's numbers as someone who is inexperienced.
Magazines was 22.9 seconds. The 3 10-round magazines was 25.51 seconds, and the 5 6-round magazines was 26.93 seconds.
On average, about 5 seconds difference from an expert to a novice. But it gets even more importantly, I want you to see another part of this, because I want to completely disavow of this false message, this false image that is being stated by the far left. Individuals like former Mayor Matt Ryan, a progressive. Individuals like the progressive-leaning Ninth Circuit Court out of California that want you to believe that you will have this miracle moment to be able to save lives, whether your own or others, to stop a shooter, a mass shooter, a criminal on a rampage, a criminal that is firing and fires 10 rounds. By the way, criminals aren't limited to 10 rounds. Criminals can fire more than 10 rounds. But assuming a criminal, for some reason, decided to follow the restrictions of the government and only fired 10 rounds in one magazine, then would you have a chance to actually stop them? Here's the answer.
One of the reasons that the magazine restrictions are being proposed is the perception that if the active shooter has fewer bullets in magazines, he will have to reload sooner, and this will create an opportunity for someone to tackle him during the reload. During our demonstration, our runner will start when he perceives the reload and stop when the next shot is fired. Our distance is approximately 25 feet. Our runner succeeded in getting about 9 feet. That is, he had 16 feet left to go when our shooter successfully completed the reload and began firing. We're going to do the same demonstration now with Christy.
Yeah. You're not going to make it. You're not going to make it. Even with an inexperienced shooter, you're not going to make it in time. More often than not. You're hiding from a mass shooter, and you're trying to take this miracle moment, and you won't make it. In fact, we saw that in Michigan just a couple days ago. The fact is, it's not a reality. And when the far left tells you that there is this miracle moment and that they're only doing this to save your life, they're lying to you because they don't know what they're talking about. They're talking about magazine clips. They have no idea what they're speaking about. Many of these people have never fired a firearm in their lives. They don't know anything about what they're speaking, but they're more than willing to affect your life. They're more than willing to take away your rights. They're more than willing to leave you defenseless to promote their political agenda. And I did mention that New York State is kind of messed up. And I want you to see what I mean. Because this is from 2019, the last year that we had full information from the FBI of crime in the United States. All links will be in the description so you can see all of the information that we're speaking about. And in New York, after having both, this is New York, after we had the 2013 New York SAFE Act. This is after having restrictions of only 10 rounds in magazines in New York State. This is after the restriction of limiting the type of firearms that can be bought in New York State. And the addition of the red flag laws, which are there to take away without due process, taking away the right of individuals to even own and possess a firearm. All of these things being done for your safety to protect you. And in 2019, 550 people were killed with a firearm. And of those 550 people, 3 were with a rifle. 3 were with a rifle. 5 were with a shotgun. Of the homicides in New York State in 2019, according to the FBI's data, 119 people were killed with a knife. 44 people were killed by hand. 3 people were killed because of a rifle. Does that make it as clear as day for you? Does that make it as clear as it could be? Perhaps not. So we will take a look. And this is from the FBI itself. And I want to show you, because I can show you the current data. And this is in the year of 2013 to 2020, according to the FBI data, looking at, and I wanted you to see the number of murders by weapon, and knives are 21% of all people who were killed. Rifles are 1%. That's at the same, they're actually below. More people were strangled in New York State from 2013 to 2020 than were killed with a rifle, which is what the New York SAFE Act, which is what the red flag laws were designed to protect you from. That is what the Ninth Circuit Court on December 1st of 2021 is trying to protect you from. More people died because of strangulation than rifles in New York State in 7 years. How about fire? Shotguns, blunt objects, hammers, and baseball bats killed 4%. 3 times as many people died because of baseball bats than rifles in New York State. More people were killed by someone's hands and feet, 6%. And I know what you might say. Well, Mike, those are percentages. What kind of numbers were they actually? Really easy. 1,000 people were killed with knives over the 7 years from 2013 to 2020. 28 people have been killed in the 7 years from 2013 to 2020. You haven't been made safer. In fact, if we look at the entire United States from 2010 to 2020 from the FBI, and we look at looking at the percentages, and this is for, again, the entire United States from 2013 to 2020. Since we saw the New York SAFE Act and California input a limitation on the number of bullets in magazines and the red flag laws, we see rifles are 2% of all people in the United States have died from rifles. 11% of people who were killed in the United States over that same 7-year period died because of knives. I want you to understand that 12,539 people, according to the FBI, died because of knives. 2,520 died from rifles, and that includes suicides. That includes all suicides, which, according to the CDC, approximately 60% of all firearm deaths, which are listed as homicides, are by firearm every year. 60% of all the people who die of a homicide is because of suicide, and it's usually with a firearm. And even with that, knives are, it's over 6 times deadlier. People who have been killed by someone's hands and their feet. 5,429 people were killed over the 7 years from 2013 to 2020 in the United States, all 50 states, versus 2,000, more than double the number of people who died because of rifles, including suicides. More people died because of baseball bats and hammers, 3,501 versus rifles. I don't know how to make it more clear for the American people. The Ninth Circuit Court isn't making you safer. They're telling you a lie. They're selling you on this hope and this idea that does not exist. It is not a reality. The most ignorant and uninformed individuals, when it comes to firearms, are trying to decide how to redefine the Second Amendment so as to make sure that you will not be able to defend yourself in your home or outside of it. And you should be speaking about this. You should be aware. This is the data. I'm giving you the information that the major news media won't bother to tell you. They'll just tell you it's for your safety. It's good for you. They're protecting you, which is a lie. Criminals know it's a lie. Police know it's a lie. And gun owners know it's a lie. But they're willing to break the Constitution to spread this lie and to take away your right to defend yourself. And for women who want to defend themselves against rape and sexual assault, for those who want to protect our children from mass shootings and school shootings, individuals who want to protect themselves at churches and other arenas, you should be very upset. Because the Ninth Circuit Court just said they would rather see you dead. That's what that ruling means. That's what that ruling means when they say you can't fire more than 10 rounds. You don't have that right. Just like they told you, you don't have a right to protect yourself outside of your home. It's very sad. But we've gone into great detail here to make sure you understand all of the information. Is it as flashy as the Ghislaine Maxwell story? No, it's not. Is it as entertaining as Jussie Smollett and his hoax and how he's trying to spin that? No, it's not. Is it as aggravating and insightful as the abortion issue? We think it is. But the news media and the internet overlords will make sure that you will see everything else and you won't know about this. Not until it's too late and you no longer have those rights. And we can see around the world what happens when people don't have a right to defend themselves. And it's never for the best interest of the public. But perhaps you think that we misunderstood. Perhaps you think our data from the FBI and news media is incorrect. Perhaps you think it's unfair of us to show you the reality of firing and switching magazines. If you do, we'd like to hear your voice. We'd like to hear what you think. Tell us in the comments. And of course, join us every week, Sunday at 2:30 p.m. Eastern Standard Time to have your voice heard on our live stream. We thank you, and we hope you'll be well.